Okay, great. So welcome again to this pre-conference workshop of the ESIL Interest Group on Migration and Refugee Law. We are here for the 9th annual conference of the European Society of International Law on technological change and international law. And this workshop is co-organized with the Human Rights Research League, which is an academic association based in Oslo and engaged in human rights research, education, advocacy and development, and also with the COSME project, which is a research project of national interest funded by the Italian Ministry of Universities and Research. And which deals with the development of community sponsorship for migrants and refugees in Europe, and also with high-tech matching tools for resettlement and relocation. The overarching theme of the General ESIL Conference aligns with, of course, our workshop. We did the best to set the scene on the positive and negative impact of recent technological advances, including AI, big data, automation, and biometrics. On refugee and migration management, in particular on the balancing exercise between administrative sustainability and fairness, procedural fairness. We received a large number of abstracts, so we are aiming for some publication opportunities for the selected speakers, but I won't say much on this. I won't disclose much on this because it will be announced at the end of the workshop. Content-wise, the selected presentation are divided into two panels. The first panel focuses on how security and control surveillance technologies shape migration control and human mobility, and how they are regulated by international and European Union law, including the interplay between artificial intelligence and interoperability in border migration management. While the second panel will host interventions on the impact of automated decision-making on migration and asylum procedures and citizenship policies, and in particular, will focus on whether it promotes neutrality, objectivity, standardization and oversight, or further fosters unfairness and discrimination and lack of transparency. We have chosen this structure for the workshop to allow the panelists to engage with each other in exploring the theoretical and practical consequences of disruptive technological change in migration and asylum law and policy, and to respond to the research question in the title, I mean, to what end? So also highlighting the transformative power of technological change in these domains. For this tight schedule to work, time management will be crucial, so I'll do my best to set a good example and contain myself. But before getting to the nitty-gritty of what we're going to discuss today, I would like to remind you all of some recent changes in the Interest Group Coordinating Committee. Two new elected members have joined the committee this year. Sissy KATSONI, who is with us. Sissy is a PhD candidate and research associate at the Institute for International Law of Peace and Armed Conflict at Bochum University. And today she will serve as discussant for the second panel. Welcome, Sissy, it's great to have you. And Giulia Raimondo should be connected or will join us in a while. Giulia Raimondo is postdoctoral researcher at the University of Luxembourg, Faculty of Law, Economics and Finance. And we, of course, congratulate them both and hope that you will enjoy the role of coordinator as much as we did over the past few years. This last reflection also allows me to thank the outgoing coordinators, Tom SYRING, who is with us today as the discussant of the first panel, and Chiara Scissa. It has been really a privilege to work with you as coordinators of this interest group. And we hope that the bond we established during this year can also be fruitful for future projects and collaborations. With this in mind, I also invite all the participants, all the members of the interest group to be active, to participate, because we really look forward to your contributions to the activities of this group. And we also take the opportunity to announce the next meeting, the next workshop, which is going to be held online on the 7th of November 2024, and is co-organized with the interest group on EU as a global actor. The workshop is going to deal with the current legal issues in search and rescue, law and policy, internationally and EU-wise. So please stay tuned. And now it's time to start the first panel on advanced technological, digital technology shaping border migration control and human mobility, by inviting Niovi VAVOULA, our first speaker, to take the floor. Niovi is from the University of Luxembourg, and she is a renowned scholar on interoperability and high-tech migration control. Niovi, the floor is yours for the next 10 minutes. And you have the power to share your screen. You already did. Thanks a lot. The title of your presentation is Interoperability and Artificial Intelligence in Large-Scale IT System, Dangerous Liaisons and Emerging Accountability Gaps. Thank you so much for being with us.
Thank you so much, Daniela, for the kind introduction. Apologies for putting you in the trouble of having to accommodate me online. Unfortunately, an orthopedic issue does not allow me to travel at the moment. As you see, this is the title of my presentation is very slightly different from the title of what I envisaged. It's only because it is aligned with a paper that I have already drafted and I shared in advance. A paper which is currently under review for publication, the findings of which I'm going to share with you in the next 9 minutes. The purpose of this paper is to look into the link and the interplay between interoperability and artificial intelligence in the operationalization of large-scale IT systems. The reason why I wanted to focus on this as a first step is because whilst interoperability has attracted quite a lot of scholarly attention, the extent to which AI systems will be embedded in the interoperability components is very much unclear. And there is what is called a creative ambiguity in the law itself, whereby only in few instances the term algorithm is used, but the term artificial intelligence has never been stated explicitly. This interplay allows us to also discuss the extent to which the AI systems that I believe will be embedded in the interoperability components will be classified in light of the AI Act as high-risk AI systems or of limited risk. And I will explain why and where there are problems with this classification and what this leads us to consider. Obviously, apart from these difficulties in classifying the AI systems, we have another emerging difficulty, which relates to how to hold these AI systems accountable. And the main accountability gap that I will discuss is that of supervision. And supervision can be done either by data protection authorities as the main supervisory authorities of databases, but also by specific boards that have been created for ETIAS and VIS in particular, but also through the market surveillance authorities, which are the supervisory authorities under the AI Act. So very briefly, and as I said, this paper is already available if you are interested in reading more about that. Interoperability embeds 4 main interoperability components plus one more. And schematically, the European Commission has this nice diagram explaining those interoperability components, a European search portal that will allow searches in all the systems at the same time based on access rights, a shared biometric matching service, which basically is a database of biometric data in all the systems, a common identity repository, which could be imagined as yellow pages with basic data of all the foreigners in the underlying systems, and a detector of multiple identities, which will hold links between people who have either the same data in different systems or they are suspected of identity fraud. These are the main interoperability components, and as I said, there is never reference as to whether they will operate on the basis of AI. However, digging below the surface, it's very clear that the shared biometric badging service will become the motor for facial recognition technology. It will hold all the facial images of foreign nationals whose data are in the underlying systems, and it will be used in order to conduct facial recognition. So the link with AI is very much embedded in this interoperability component. An AI system, which in principle is a high-risk one, if the data are used for identification purposes. The second component that we may see a linkage, an interplay with AI is the multiple identity detector. And Francesca, which I believe should be in the room, I haven't seen her, already in her thesis, she hypothesized that the MID will work on the basis of artificial intelligence. I tried to look more on that, and I found that in order to create those linkages between data in the different systems, potential AI in order to compare text, for instance, to compare the names, the family names of individuals, could be used. The problem that we have with MID is whether this is a tool for migration or a tool for law enforcement. And depending on how we classify MID, it will fall under different provisions of the AI Act. This is because, as I said, the MID is a tool that is meant to detect identity fraud. So the linkage with law enforcement is very, very clear. And from that perspective, MID could be classified as a profiling tool, which will fall under the law enforcement provisions of the AI Act, and it will be classified thus as a high risk. However, if we look at it from the perspective of migration, MID could also be considered as a migration tool, and then it will fall under different provisions of the AI Act on migration. And there is possibility to actually declassify MID not as a high-risk system, but as potentially a limited risk system, which means less safeguards. Finally, there is one more hidden interoperability component, which is the Common Repository for Reporting and Statistics. This is basically a database with statistical data, so a non-personal data database, which means that by default, the EDPS will not supervise because it's a non-personal data database, but also it is a repository that may use AI in devising tailor-made statistical data. The problem there that we have is that, again, we don't know whether this can be classified as a high-risk AI system that will assist in profiling individuals, or it can be considered as a limited risk high AI system because falls under an exception of the AI Act, and it helps only for a preparatory task, the preparatory task of profiling itself. As you can imagine, all these already show that we have problems with this classification, and the safeguards of the AI Act may or may not be applicable in the components. So not only we have lack of transparency as to the application of AI in the interoperability, but also as to whether the safeguards of the AI Act will apply and to what extent. Already that apart creates a series of problems. As I said, the Common Repository will not probably be subject to the supervision of the EDPS because it doesn't hold personal data. Other accountability gaps that I have discussed elsewhere has to do with the application of the Schengen evaluation and monitoring mechanism. But what I want to highlight in the last 2 or 3 minutes has to do with how these interoperable and potentially AI-reliant systems can be supervised. Supervision, as I said, is principally conducted by national supervisory authorities and the DPS, what I've called the human over the loop, rather than the human in the loop that is embedded in the final decision making, the humans over the loop. However, in light of this complexified ecosystem, the article proposes that supervision needs to become a continuous ongoing process that takes place on the ground in order to follow the different data flows. In other words, national data protection authorities need to get their hands dirty. Obviously, all these data processing activities create logs, but we're talking about billions of logs, and therefore, even though these are very useful, I call them as a curse disguised in a blessing. And in light of the use of AI, I envisage that the challenges for fundamental rights go beyond data protection, in order also to encompass other fundamental rights, such as non-discrimination. And therefore, supervision should also encompass other fundamental rights, especially non-discrimination, something which is in line with the judgment of the Court of Justice in Ligue des Droits Humains. And I propose an individual-centric approach rather than a data-centric approach. As I said, the problem still is that there may be still supervision gaps, with the common repository of reporting and statistics being a major supervision blind spot. A second supervisory function will be through the fundamental rights guidance boards that ETIAS and VIS have, because they embed profiling of visa travelers and individuals from visa-free countries. But those boards do not have a full supervisory function, just an appraisal function. However, because the EDPS is part of these boards, they have the potential to identify issues that can then be followed up for further supervision on the ground. And finally, the AI Act itself provides for supervision by so-called market surveillance authorities. The problem is that we do not know whether this will be the DPAs, which will ensure continuity and a holistic and consistent approach in supervision, or other authorities. If there will be other authorities, then they need to coordinate with the data protection authorities in order to supervise fully what is happening with interoperable AI systems. I will finish. The paper has much more flesh and juice in there. Finally, we see that the application of AI is very much unclear. This is also a major rule of law challenge. And this also creates problems with classification under the AI Act, which means that already is fraught with exceptions in the field of migration, asylum, and border management. And these exceptions can be leveraged so that interoperability will not have sufficient safeguards as regards the application of AI. Finally, these emerging gaps in supervision needs us to revisit the way that supervision already takes place in order to have a holistic, human-centric supervision of large-scale IT systems with AI and interoperability. Thank you so much. I look forward to Tom's comments and any queries and comments from the audience. Thank you.
Thanks a lot. Just a second there, I turn on the camera. Thanks a lot, Niovi. It was really enlightening and insightful presentation, shedding light on the interoperability components and also touching upon the interplay between artificial intelligence and interoperability. I like very much this idea of investigating the centrality of the human over the loop, as you say in your paper. And also the attention you put on the exception of Article 6, paragraph 3 of the AI regulation, and whether it could work as an exception with its own included exception. It's quite interesting. Let's leave it for the Q&A session later on. I don't know if you can stay with us. That would be great. Thanks a lot. And let's move on quickly to the second panelist, Francesca TASSINARI, who invite to join us here. Francesca is from the University of Basque Country, and she will talk about profiling based on high epidemic risk indicators. What can the ETIAS tell us about migrants' health? So Francesca, you have the floor for the next 10 minutes. I don't know if you want to sit or... No, then you can, yeah.
It's the same.
I guess Niovi can hear you also from there. Yeah, okay, maybe it's better for the audio. Yeah.
So thank you very much. Good afternoon, everyone. Hi also to Niovi, and thank you also for recalling hard work in PhD time. Thank you, Daniela, also for the presentation. Today, I would like to focus actually to one of the large-scale IT systems that are part of the interoperability infrastructure, and which is the ETIAS, European Travel Information Authorization System. Sometimes I prefer it as ETIAS or ETIAS. The pronunciation change depending also on the language, but it should be ETIAS in principles. It was reproposed, the system, by the European Commission back in 2016, and its relevance actually relies on the forecasting technology it incorporates in its functioning and was followed in other EU initiatives, for example, in the visa information system. My discussion here today would like to spot a specific angle, which I think has not been that much tackled so far, and perfectly match with the work I'm developing currently in Bilbao concerning public health. So it is actually related to the ETIAS public health function, and above all, the interferences it might cause on third country national rights to privacy and data protection in case health data are directly or indirectly processed. ETIAS, as a lot of us managing at least or navigating in the interoperability and large-scale IT system world, it's a very peculiar system because it's the only one that does not contain biometric, but also because it's a self-declaratory system in which the applicant itself had to insert the data in Latin character. And also, it requires the applicant to answer a series of questions directly filled in the application, but surprisingly, it asks for no data concerning health, neither by filling in the application nor by answering to specific questions. In reality, the European Commission originally proposed to insert a question related to whether the migrant would suppose a risk of epidemics or health-related contagious disease, but the Parliament opposed to it. And in the end, what was negotiated and agreed was that reference to health data should have been inserted in the ETIAS screening rules. What's the result then? Well, high epidemic risks, actually, which must be formulated by the ETIAS central unit, meaning Frontex, and from that creates new indicators. We'll have to compare the ETIAS applications of each third country national with the so-called screening rules. And the information, in order to elaborate these high epidemic risks that will go through the algorithm enabling profiling, the ETIAS central units, again, Frontex, will have to use three different sources of information. The WHO information, the information provided by the European Center for Disease Prevention and Control, ECDC, and the member states themselves. So this information is gathered. For example, in the case of the WHO, is information related to emergency of international concern regarding health risk, including pandemics, which was actually inserted after COVID-19 crisis, through the national authority or the focal points. And the disease outbreaks could be or not published in disease outbreaks of news of the WHO official web page. As a general rule, personal data should not be processed because the WHO should process the data in a confidential way, but exceptionally, it could happen. And actually, in the WHO International Health Regulations of 2005, we find some data protection rules. In the case of the ECDC, again, the ECDC enabled the sharing of information through surveillance platform, which is interoperable it is at central platform, interoperable at national level, wants to, let's say, make member states informed and reactive in case of risk of high cross-borders epidemic risks as health risks that can affect all the EU member states. And in this regard, it also provides for a so-called early warning and response systems, so a sort of alerts that the member state should issue to make the other informed that there is an emergency in this sense. Here again, there is the possibility to process in this framework personal data. And the last point is the member state. The member state mainly used the channels offered by the ECDC and could share personal data through also the early warning and response systems as far as contact tracing and medical evacuation procedures are concerned. The contact tracing, of course, reminds us of the COVID-19 moment where we had this sort of apps that were enabling to to know the person, whether the person you have been in contact with another person that was ill and carry disease. From this information, as I was saying, the ETIAS Central Unit should elaborate high epidemic risks. So in substance, it has to find out a set of characteristics that belong to specific groups of travelers in order to say that those persons have some sort of characteristics and could represent a high epidemic risk. Together with the high epidemic risk, there are so-called indicators associated, which are fixed-term parameters like the individual age, sex, nationality, education, or work that have to be matched once the application is submitted in order to understand whether the person represents a high epidemic risk. We all know from previous literature, including Niovi herself, how the procedure functions in case there is a hit, meaning that the application is sent and the person represents a high epidemic risk. The issuance of the travel authorization will be made not by the in automated way by the TIAS central unit or central system, but from by the TIAS national unit. So it will be up to the members to decide whether the person representing a high epidemic risk is authorized or not to travel. So all this to say what? Is to say that the concept of health data has been a lot elaborated during the scholarship, and there had been huge debates outside the ETIAS context, because they are sensitive data that represent a special categories of data regulated under Article 9 of the GDPR. And if we follow, for example, Professor Casabona studies, we found that health data in reality contain a lot of information on our present, past, and future health. And it's not only related to our direct health status, but also they reveal, for example, where we live, which are our habits, our costumes. So a lot of sensitive information that the GDPR wants to protect. In the case of the ETIAS, it is, in my opinion, astonishing that in reality, the health status is not declared by the person, but could be inferred indirectly. And there are two moments in which we have to look for safeguards. The first one is the proper elaboration of the ETIAS screening rules. Because when the Frontex, the ETIAS Central Unit, will have to elaborate these screening rules, it will take information from the three main sources I've mentioned before, WHO, ECDC, and the member states. And I've tried to highlight that it includes also personal data and health data. So what I've been proposing in the paper circulated was that maybe an alternative, and as we find also in the literature, that pseudonymization and anonymization as concepts that are really difficult to define because of the evolving of technology, so anonymization seems to be not possible anymore. What I proposed was, for example, to use synthetic data. So the possibility that the elaboration of screening rules is based on artificial data that are delinked from the original source and replying the same patterns and the same characteristics, but without affecting the data subject. The second part, and the second and last part of the research concerned the possibility to infer actually the individual's status based on a hit when the application is actually submitted. And here it is interesting to know that actually the person should be, it's not clear by the TS regulation whether actually and how the person will be informed about the possibility that he is found to have an health status which is not compatible with EU standards. Actually, the TS regulation says that the person should be informed about the data that have been collected from the application. But in this case, we are not talking about data collected by the ETIAS application, but elaborated by Frontex itself. We all know already from the literature that there are also huge concerns on how to explain to the individual itself that the algorithm has elaborated this risk. So in terms of transparency and fairness, which is another important aspect to be taken into account, plus the fact that in the case of the WHO, there are also confidentiality rules to apply. So maybe it will be not possible to reveal concretely how the information has been furnished to the ETIAS central unit. And last but not least, another factor that I have pointed out concerned the update of the screening rules. So I was wondering how to ensure that, for example, in case the risk indicators are updated after 6 months and the person will no longer represent a high epidemic risk, how to ensure what will happen? Will the authorization be issued after 6 months, which is of course maybe useless? Will the individual, the third country national, informed that now he is eligible to enter into the EU, or it will not? Because the ETIAS regulation does not refer to that. It only mentioned the possibility to update or rectify the data based on the application, so based on the individual's own reaction. And this is all from my side, and I thank you very much for your attention.
Thanks a lot, Francesca, for adding another piece to the puzzle. And for explaining what are the risks and what should be the safeguards, especially with regards to the functions of Frontex, the function of the ETIAS central unit. It's quite interesting, this idea of synthetic data and the linking from the original source. And also, of course, the problem of information of the data subject on the way in which the data are elaborated. So many thanks for this thought-provoking presentation. We can now give the floor to Dimitra PAPAGEORGIOU. I hope the pronunciation is fine. Yes. University of Athens. Dimitra will talk about the techno borders, maritime surveillance, and migration in the Mediterranean Sea. I know that you sent us an updated version of the presentation. So yeah, just a second that when download it.
I will share it, but
yeah,
if you stop sharing your screen.
Yeah.
Great. You disable. You need to.
You. Okay. Yes, I can move, so the floor is yours.
Yeah. So use this.
Okay. Thank you so much for having us here and give us the opportunity to present our findings of our research paper on techno borders, maritime surveillance and migration in the Mediterranean Sea. as I mean, me and my colleague Eva Davala, who couldn't make it due to an orthopedic problem herself. But it is a work in progress, so your feedback would be highly appreciated, and we hope to a fruitful discussion afterwards. We will focus on new technologies in maritime surveillance in the Mediterranean in the context of migration. So monitoring human activity at sea is instrumental to an efficient border management policy. The European Union thinks so too, with the use of new technologies being of paramount importance. Why? Because states, EU member states, and the European Union, they have an interest in possessing real-time information regarding security incidents at sea, so that they know how to address them effectively, promptly, and take the appropriate preventive or responsive measures. Until recently, the border control depended on the physical presence at sea or at land. But recently, due to the security risks that happen on the maritime domain, border governance no longer takes place at natural borders, but has entered an era of deterritorialization. The control has been removed from the natural borders, especially after 2015 and afterwards, which again is already old news, this deterritorialization, and we have entered this era of digitalization. The new technologies have become indispensable to the EU policy. So actually, the EU borders have become EU techno borders. And this has led to this is why what new technologies do better is that they contribute to an effective maritime domain awareness. What is go down? I can find them.
It has disappeared, right?
Yeah, it has disappeared, exactly. And I can move.
Let me- Where-
Yeah. So, maritime domain awareness is the effective understanding of any activity associated with the maritime domain that could impact upon the security, safety, economy, or environment. And it implies the collection, fusion, and dissemination of enormous quantities of data, intelligence, and information to enrich a comprehensive common operating picture. The knowledge alone of a position of a vessel, for example, in the sea, is not enough. As the definition itself indicates, we need an effective understanding, meaning an understanding of the real nature of what is being monitored and of the threat that is being under monitor, whether it's threatening or illegal or not. For this reason, a number of systems have been developed that ensure that the states have indeed this necessary information. The most common technologies and sensor types that are used in maritime domain awareness are these systems: automatic identification systems, SAR and RF systems. There are specific obligations of vessels to carry such systems on board. Obligations that come from the SOLAS Convention or the SOLAS regulation. But again, they do not all give the same possibilities. For example, AIS systems, they are part of commercial vessels equipment in accordance with the SOLAS Convention, which requires that all vessels, they have and they can provide information about the ship's, the vessel's type or speed or a destination and other safety-related information. So it is quite useful when you're monitoring movement in the sea in general, but it is generally not carried out by vessels that are engaged in illegal activities, smuggling, for example. In such cases, SIR systems and RF systems are used together, mainly for law enforcement purposes. There is a vast variety. We're talking about a variety of tools, not specifically meant to be used in the migration context. So they're used either for, in general, for vessel monitoring or for environmental purposes, such as the GNSS systems, which, however, they give the possibility, when used together or in combination or alone, to provide information that that each state needs to monitor and manage migration for maritime surveillance in the migration context. We keep that aside because we will come back to this repurposing of the new technologies. As you probably know, the EU agencies have made vast use of these new technologies. Frontex itself, in their webpage, they admit that they know what's going on in Europe's borders, where the threats are, how to react. They do it by using their own surveillance systems to coordinate the response. Also, the newly adopted EU Migration Pact on the EU Pact on Migration and Asylum, it provides the EU with a legal framework and tools to further enhance the effective management of its external borders. But also international organizations and civil society organizations and private companies have also entered the game, and they have developed their own tools for migration monitoring. I bring as an example the International Organization for Migration that has developed this DTM, this is a displacement tracking metrics, which relies on data that they receive from other UN agencies or other stakeholders and implementing partners. And DTM has been used at sea borders in the Mediterranean by IOM Spain, Greece, and Italy, in the context of flow monitoring surveys conducted with migrants arriving, arriving either in the central Mediterranean route or the eastern Mediterranean route, or the western Mediterranean route. Similar is the IT flows database, which is an EU research-funded project with the purpose to providing accurate prediction of migration flows in the EU. This has been done through the EU Maker tool. So we see in general that the European Union gives a lot of money to the development of new tools for maritime surveillance, for border surveillance in general. Millions and millions of euro, and especially Greece, where I come from, stands out as the country receiving the largest amount so far of resources in absolute terms, more than 1 billion euros for development of new technologies for maritime security. So in principle, this use of new technologies in border surveillance is not per se bad. Why? Because EU member states are in a better position to receive information of the vessels in distress and respond, especially regarding search and rescue operations. Also, the knowledge that the vessel in distress is in distress may also trigger jurisdiction of the EU member states. So and by extension, the obligation to ensure the right of life for these persons. Of course, this is also debatable. Just to remind you, the latest shipwreck in Pylos, where both the EU agencies and the member states failed to respond promptly and perform successful operation. So this is exactly what the concern is with the new technologies. The concern that, as I mentioned earlier, new technologies and specific tools can be repurposed and instead of be used for environmental purposes or for weather monitoring, they can be used and repurposed for preventing access to the territory of migrants or to prevent them from asylum processes, thus leading to the further securitization of the borders. This can also be triggered through the interoperability probably of the platforms that Niovi spoke earlier. Maybe she can comment on that later. Indeed, there is concern, and the special rapporteur on racial discrimination and xenophobia mentioned in relation to the tools developed by the international organizations. The rapporteur mentioned specifically IOM and UNHCR that they should ensure that they use an implementation of mandatory ongoing human rights assessment protocols for digital border technologies once deployed. They must make sure that the systems protect basic human rights. And also, once private sector enters the game, this is where the states lose oversight. So you need better scrutiny. There is a regulatory gap. States cannot monitor exactly what the information received or how things work. So, and with the pretext of national security, again, also there are reasons to justify exemptions from transparency and access to information. And even the EU AI Act says that AI systems are developed or used exclusively for national security purposes that are exempted from the scope of obligation. So again, this also raises some concerns regarding the use of new technologies in border surveillance. Thank you.
Many thanks, Dimitra, for this comprehensive analysis of all the techno borders tools, and also for pinpointing the issue of repurposing, which, however, is also part of the European Union, policy, since, I mean, it's quite obvious that the surveillance and security component of the last reform, also concerning the search and rescue operation, goes in the direction of fostering those instruments for purposes of containment and prevention of the flows. Therefore, I mean, the repurposing is in the design, in a way, of these reforms. And I go back to the creative ambiguity, which was raised at the beginning of this panel by Niovi, and also for pinpointing the role of private sector and the problem with transparency when it comes to the development and application of private-led tools. We can now move to the last presenter of the first panel, Irene BACEIREDO MACHO, University of Deusto. Welcome, Irene. You will present on the data protection concern in the framework of Eurosur, so we can complete the picture, and you have the floor for the next 10 minutes. Thank you.
Yo compartir el PowerPoint. ¿Quieres en PowerPoint? Sí, mejor.
So, hello everyone, my name is Irene BACEIREDO, and I'm a second-year PhD student at the University of Deusto in Spain. My PhD focuses on the responsibility of Frontex for potential fundamental rights violations caused by the sharing of information in the framework of Eurosur, and I'm doing my thesis under the supervision of Professor David Fernández Rojo. And today I'm going to present on one part of my PhD thesis, which will later be part of one of the chapters. So to start with and to set a bit of the ground, Eurosur is the European border and surveillance system, and the European Commission first made reference to this system in 2006 in a communication to the Council, in which they aim to find for a mechanism to help improve the surveillance of the southern maritime borders. And in 2008, the Commission proposed a border package, and one of the communications in this border package focused on the creation of Eurosur. Following the developments established on this communication, the Commission decided to establish this system in two phases. The first one would focus on the linking of the existing national border surveillance systems, and the second would focus on replacing the existing mechanisms. So Eurosur was mainly constructed on a test phase in parallel with the legislative proposal for the system, and this is why all of the member states were so prone to adopt the system, because they had already tested it and then they had to approve the regulation. And so the pilot project served as a basis for the regulation, which was finally adopted in 2013, but now has been repealed by the current Frontex regulation. So Eurosur was established for a general objective, which was the detection, prevention, and fight against irregular immigration and cross-border crime, and also for the protection and saving of lives of migrants at sea. However, it also had two specific purposes, which are the situational awareness and the enhancement of reaction capability. Situational awareness is defined as the ability to monitor illegal cross-border activities in order to find reason grounds for reaction measures, and reaction capability is the ability to perform actions aimed at countering illegal cross-border activities at the external borders, including the means and timelines to react adequately. So Eurosur is mainly composed by 4 elements. The first of it is the national coordination centers, which are located in each member state of the European Union, and they aim at connecting all of the authorities competent in border control, and they are also connected to the Frontex Situation Center. Then we have the situational pictures. These are an aggregation of georeference near real-time data, which includes pictures and information gathered by the systems. There are 3 types of situational pictures. First, we have the national situation pictures, which are created by the national coordination centers, and they include the external borders of the member states and also the pre-frontier area. Then we have the European situational picture, which is created by Frontex using the information collected both by the agency but also by the member states. And then we have the specific situational picture, which is one of the main concerns here, which I will be looking into in a bit. Then we have Eurosur fusion services, which provides it aims at providing services for the establishment of situational pictures. This can be requested either by Frontex or by the member states, and it mainly consists on the cooperation of Frontex with other agencies, such as like the Satellite Center or the European Fisheries Control Authority. And lastly, all of this information is shared in the Eurosur communication network, which is a secure network that aims at exchanging data in a near real-time manner. So as I mentioned previously, one of the main concerns in the components of Eurosur is the specific situational picture. This picture, instead of focusing on a map or on a specific geographical area, consists mainly on the operational activities of the agency at the external borders, or is either intended to share information with European Union institutions, bodies, offices, and agencies, and other international organizations, or with third countries. The sharing of information is performed on the basis of working arrangements mainly, and this is a bit of a problem because most of them are outdated and lack sufficient human rights safeguards. So to move on with the data protection concerns caused by this system, as I mentioned just now, one of the main concerns is that the working arrangements are completely outdated in most part. They don't have sufficient human rights safeguards. Most of them don't even mention human rights at all. And the second problem is the data protection framework of regulation of the Frontex regulation does not have the sufficient safeguards for data protection. So to aim at explaining briefly the data protection framework in this context, Article 86 of the Frontex regulation establishes the general rules. In this provision, paragraph 2 aims at that the management board is to adopt the rules for implementing the European Union data protection regulation. And in this regard, in 2021, the management board adopted decision 68/2021, which I'll go on in a bit. Then Article 87 establishes that Frontex may actually process personal data for the purposes of Eurosur in accordance with Article 89. And lastly, Article 89 establishes that in the context of Eurosur, personal data cannot be processed, but it has a few exceptions. In paragraph 2, it is stated that ship and aircraft identification numbers can be processed for the purposes of Eurosur. But what's mainly concerning here is that paragraph 3 establishes that other types of personal data can actually be processed for the purposes of Eurosur, which are established in Article 18, which are the ones that I mentioned earlier, the prevention, detection, and fight against irregular migration and cross-border crime. So in this regard, the European Data Protection Supervisor established in 2022 that the decision of the management board did not have adequate safeguards and it missed specific rules for the processing of personal data. And it also established that the regulation of Frontex did include very few elements as regards the processing of personal data. So in response to this, in the beginning of this year, the Frontex Management Board adopted a new decision in which most of the missing elements for the processing of personal data are now covered. And it actually includes detailed rules for Eurosur, which the previous Management Board decision did not include. However, there are still remaining concerns because this decision exclusively develops what personal data may be processed for the purposes of the Eurosur fusion services, but is silent as regards Article 89, paragraph 3. So it includes the cases in which ship and aircraft identification numbers may be processed, but it does not say anything about what other types of data can be processed in the context of Eurosur. The only update that it has been made is that it explicitly mentions what the purposes of Eurosur are, but these are still very vague, and it could turn into a breach of purpose limitation of data and into a violation of the right to data protections as established in Article 8 of the Charter of the Fundamental Rights of the Union. So this has been everything, and if you have any questions, I'll be happy to answer. Thank you very much.
Many thanks, Irene, for completing the picture of the European techno borders, adding lights on Eurosur. It's an old tool, I mean, one of the oldest, but you know, extremely modified and boosted since it's part of the Frontex regulation. The purpose blurring here is the central issue, and I'm sure it's going to be discussed in the Q&A. And it's now time for the discussion. So I invite our discussant Tom SYRING to join us and break the ice. And then, of course, we will open the floor to the audience. Thank you very much.
Oh.
Yeah, maybe if you go there, the audience.
Okay.
Why the image continues there? Yeah.
Maybe if the speakers want to come to the front, it's a good way to, you know, be closer to the. Yeah, I guess you can see here, and someone about to see. Yeah.
Yes, thank you, Daniela. First of all, I wanted to come back to what you mentioned earlier in your introduction, that we have been collaborating for a long time, both as coordinating team members and now with Human Rights Research League. I think it's the third in a row where we contributed or collaborated or co-organized. And I want to take this opportunity to say, yes, of course, we would be interested also in the future to organize things like that together. But I also want to say that there's a little bit of sorrow involved, because one of the ideas for our collaboration here has always been that we wanted to try at least to expand the reach of the interest group and of ESIL beyond Europe. So for that reason, we, like the Human Rights Research League, has always had some funds reserved to enable those who are not within the Western part of the world, if you want to use that term, to contribute or take part in sessions like that. And sometimes we've had a lot applications from other regions. Once we had at least 3 also selected. And I think this year we did not, and that might be in part because it's easier to take part when all of it is online. Now it's not. So even with the contribution from our part, it's still a huge sum for people to take part. But maybe that's not the only reason. So I would encourage everyone to see whether one can expand that also in the future, and, you know, spread all the calls for paper, etc., to all other regions. Because even though it's a European Society of International Law, it doesn't mean that it's still international law, and the same applies, and I said the same in the American Society of International Law, where I also did a lot of work to also expand that. that being said, the issues today, data security. Well, it reminds me of what happened today. When I just got here, I was sans papier. I didn't have any papers. To this conference, my badge was not there. Then I said, well, I did register, so what's going on? Eventually they typed it, or no, they wrote it by hand, but it only had a name on no affiliation, so they would fix the rest later. So I waited for the copy there, and then they got me the printout, and it said, Tom Syring, University of Cyprus. And I've not been there or had any affiliation with Cyprus, so obviously that was wrong, and then eventually they came back the third time. But that made me think of our topic here and data security and all the issues involved. And well, it's a major concern. If even a simple thing like that may go wrong, I still don't know how those mix-ups happened. But it reminds me of the topics we're discussing today, and I think they're very fascinating, exciting. I wish that at least some of the longer papers I would have received earlier, because as I said to our co-chairs, whatever didn't come in last week, I really could only take a glance at, and that's why I have to limit comments on those to a very few points. On the other hand, as we have a lot of people working on the same field and even closer to what my field would be, and some of you even reference each other's papers in your papers, I'm sure we can have good discussions with all those we have in the room and rather reserve more time for that. But in general, what all the papers showed and dealt with, I think those are important, exciting topics, problematic issues, pitching security versus privacy rights, etc. And because of that, I think they're very important to be dealt with here. And I want to thank everyone who wrote the papers and everyone working in those fields for engaging in those topics, because we obviously need much more knowledge on a lot of them. That being said, let's see. We go down the list. And bear with me, I only noted down, yeah, that's the program there.
Yeah.
Noted down a few points as I was on the plane. Yes. So Niovi VAVOULA's paper, or rather article by now, I should say, what I found the most striking and probably interesting to explore was, can't recall exactly where in the paper, but you mentioned the 3-year gap between or the delay in bringing large-scale IT systems within the scope of the AI Act. And as a general concern of law, I was wondering, and I probably would invite everyone else to discuss how we can even accept that we have like 3 years of, as it was stated in the paper, sort of a black hole or a black box, during which there's very little oversight over such an enormous topic. And the second thing I noticed and I thought was very interesting was, if I read it correctly, discussing the logs that one would use to track whether information has been collected and passed on and analyzed in a correct way or not. And in order to do that, because there, as the paper says, would be billions of logs, and the human oversight by humans alone would probably be impossible. So what the paper then looks at into or states is that you might need to use AR for that. So you would have to use AR in order to have oversight with AI in order to have oversight with AI tools, which seems logical since there are so huge numbers, but on the other hand, it also seems highly problematic and almost circular, but not circular in the sense that you make a circular argument, because you say that from the outset that this is the challenge, but maybe it's the only way to deal with it. So on page 13, when you have logs of that kind, and that's probably the well, the monster we created with collecting data on almost anything. I jumped to Francesca's paper, and I have a few comments in the margin, so I'm just going to go back and forth on those. Some of them may be for clarification, maybe just for me to enlighten me. Some of it might be something that you also wonder about. The first thing I was stopping at was that somewhere it stated on, it's not that, doesn't have page number, so I don't know exactly which page it is, but it said somewhere that no health documents should be required for travelers in international traffic. Was that restricted to the EU, or did you really mean international traffic in general? I mean, should is one thing, but obviously to certain countries you always need health certificates, like yellow fever or so, etc. Then, yes, simply because I didn't follow that so closely, it states that the European Commission is due to adopt a delegated act with a list of categories of personal data that may be exchanged for the coordination of contact tracing measures. Has that happened already, or when is it expected to be taking part, or is it already, but only in the future, still in the loop? And then what I found one of the most interesting thoughts or parts of the paper when you talk about risk indicators, known parameters, age range, sex, nationality, etc. And then it says that risk indicators should be targeted and proportionate and shall in no circumstances be based solely on a person's sex or age. I was wondering, is there anything in those regulations that say anything about what way, or like what key to be used, what way to be put on each of those parameters, or is that up to, I don't know, whose discretion? How are they weighted against each other? And if it's not known, should it be known, or who's in charge of those determinations? Then, yeah, I don't have the page numbers. When you mention risks to raw data, and that certain categories of precisely sensitive data seem to be impossible to anonymize. And also, or even I think when you mentioned synthetic data, there might be a real risk of re-identification unless you have a privacy assurance assessment. And I was wondering, given that, well, scary enough, as you say, raw data may be impossible to anonymize, but even synthetic data, how do you even, I mean, might be a technical issue, or maybe it's not even 100% possible, or you would have to be a tech geek to know more of the details. I would be interested to know if someone knows, or if you can explain that more. How sure could one be, or how is it even supposed to be, that one adopts a privacy assurance assessment to verify that there is no real risk of re-identification? I mean, can you even have that? Or is that just something you sign off on? We've made a privacy assurance assessment, and that's why it's now it's secured. So whether this kind of privacy assurance would be the solution to all our problems here or not, is something I would like, or even love to hear more about, or hear others' input on. And then what troubled me probably the most was, or to would have spin it positively, it's an interesting thought that you said the question rises as to what extent the TCN, or the person concerned, is entitled to know how the risk indicators have been processed, and why, if so, its application is rejected. So technically, if I understand that correctly, in those circumstances, the person concerned would learn in this way that he or she is or represents a health risk. So what would that do then to the right not to know about your, say, health status? I mean, it depends on what exactly they collect, or what kind of health risk we're talking about. But if I remember correctly, there may be people who do not want to know whether they're have terminal illness or so, and in this way, they would have, or they would know, although they wouldn't want to. And that, I think, is, yeah, you mentioned that, highly problematic, and that's probably worth discussing further. Yeah. So. Yeah. The others, yeah, will be, not least because I didn't have much on that. So if you say, Dimitra, yes, since I didn't see much before, apart from the abstract, I don't want to say a lot here. Mainly a question or two. I think you stated that underwater centering techniques, but that they fail to meet real-time constraints, and I probably didn't pay enough attention to that, but want to know what exactly, how they differ from other censoring techniques, and why they cannot be more or less real-time. And the second point there was forecast migration flows. You stated that CSOs want to, or advocate for, a ban under the AI Act, as those are unacceptable risks to fundamental rights. Yeah, I would like to also, like you or others, to expand on that and maybe discuss, do they or are they justified or not, those risks? And then finally, Irene's paper. Let me just briefly see. Yes, you said, for example, after the pertinent evaluation of the Eurosur regulation, the Commission concluded that Eurosur should be encompassed in the forthcoming Frontex regulation. in order to maximize the operational mandate of the agency, as well as to expand the scope of the system so as to cover the majority of the components of integrated border management. Did they reach their goal? If that was the goal, it's something. I wonder, then you also discussed or very briefly mentioned it is the latter situational picture that arises. More debate given that it is aimed at sharing information with third countries or international organizations, mainly on the basis of working arrangements, which most of them are outdated, lack sufficient human rights safeguards. That part I was very interested in, but then you said later on that this paper will not deal with it. But I assume now, because I didn't know what it would be used for, but if it's, all of it is part of a PhD, then I assume you discussed that somewhere else. Okay. Otherwise, I would have liked to have it in that paper. That's good. At least it's in there, or will be. And maybe just one last. Yeah, that's maybe for the general discussion. Sometimes you say that there are some wording in the regulations that are too vague or leave room or too much room maybe for what may be applied or not. And I was wondering, in those circumstances, would it be possible to have an exhaustive enumeration of cases or situations that may be enable or allow the processing of personal data, for example, in the framework of EFS? Or is an exhaustive enumeration never possible in those circumstances? Because, you can only have so much detailed knowledge of what may be relevant in the future. Yeah, I think with those points, given the time constraints and all the knowledge in the room, I'll leave you to it.
Thank you so much, Tom, for this great discussion. We still have some time for the question from the audience. So if anyone wants to intervene, please come to the front. And for the question. I believe there are no questions.
Okay, we can start.
Yeah, this can be an option, but for the sake of time, this was wondering whether yeah, okay, so let's give the floor to the presenters first, and then maybe someone will be less shy. Okay, let's proceed in reverse order. So let's start from Irene or Irene. I don't know which. Irene. Yes.
So well, I'll start with the second question. Yeah, the working arrangement.
Yeah, if you can
Yeah.
keep your
Yeah.
response in 1 minute and
Yeah.
a half.
Okay. So the part on the working arrangements is in another part of the PhD, so I thought it wouldn't be very relevant for the presentation today. But I will keep that into consideration. And then as for if Eurosur should be encompassed in the Frontex regulation, if they reached the goal, I'm actually not very sure, and I've discussed it with many scholars and people that work in this field, and many of them say that now it's even messier than before. So I'm not sure if it's better or worse. I still have to look into that. And as for the other things, I still have to do more research on the wording of the regulation, but I do believe that there are many parts of it that leaves a lot of room for interpretation, and that personal data could actually be processed in order to for the purposes of Eurosur. But thank you for the comments, and if there's any other question, I'll be happy to answer it.
I actually have to raise a question on the first point highlighted by Tom, because I mean one of the questions could be whether the inclusion of Eurosur into the Frontex regulation can trigger all the obligation on Frontex, also within the remit of Eurosur. in terms of, fundamental rights protection and oversight. So this could be, an interesting research question for me, at least, to look at. I don't know if you considering this for your PhD thesis or for some articles, but this could be interesting too.
Yeah. I'm considering it, and also what human rights framework is applicable to these cases, because there are many actors that are involved in the process. So
Especially because in the original regulation of Euros, it was stated that one of the main purposes was to save life at sea.
Yeah.
And now it's even more complicated, since Frontex is clearly security agency put into the last mandate. So it can be a problem of, balancing
definitely
goals and objectives. Okay, thank you.
Thank you.
Okay, so Dimitra, would you like to take to account, or it would be better for, if you don't mind?
Yeah, sure. So regarding the nature of the underwater sensor network, so I'm not sure how they work. I mean, I understand that they obtain large scale data, so it's really hard to use them real time for migration monitoring purposes, where you need real time data. They have large scale data, especially for environmental purposes, for oil exploration and exploitation. So it's different in the nature of data that these systems use. So they're not actually very useful for border surveillance. This is my understanding, but I'm not sure how they actually work, to be honest. This is as far as the technical description goes. I don't know if this.
I'm just trying to figure it out myself, because I know that they have same way you can track flight tracker, you can track ships and vessels, but maybe it doesn't work because that only applies to those that are registered and big enough, and not if you come in.
Exactly, and for example, there are other systems like for example, the SIR systems says that, for example, they are good in recognizing still, so they can tell if something from a party is a ship or an island, but they're not good with wood or other materials. So depending on the system and the monitor and the potential that they have, they can use or not, or better or worse, for migration movements and this kind of water surveillance. So it depends really on the capabilities of each system. He's an expert on that. So, yes, but I'm still trying to figure out how these systems works and how, and this is why they're not used alone. They're used usually 2 or 3 systems at once, or in combination in any case.
Yes, may I ask a slightly provocative question? So in this particular context, we keep talking about monitoring and the use of technology for the purposes of holding private actors accountable, or monitoring migrants themselves or traffickers, etc. But it is also used in order to hold states accountable, at least in principle, right? For example, we had a recent investigation by the forensic architecture with satellite images that proved essentially for the secret that you mentioned before, that the Hellenic Coast Guard did have responsibility for this incident, that the AIS system was not activated as it should have under international law. So is this something that is actually currently discussed in this particular context, like the reverse use of the same technology?
This is something that we will be discussing in our paper, yes, at least because there is this regulatory gap when the private actors come in the field, because the European Union gives money, they do the research, they give their tools, but in in the point of accountability, and where you know, and the interplay and the intersection between, you know, the responsibility of states, the private actors. This is a bit blurry. So, and it needs to be discussed, if you ask me. But yeah, and I think everybody agrees to that. And this is why I think exactly there is this there's this lawsuit by Sea-Watch against Frontex in front of the General Court of the European Union in relation, for example, to lack of documentation containing information for the interception that happened to migrants traveling from Libya to Malta. So again, the notion of accountability and responsibility of international organizations, EU agencies, and how they use this data, and to what extent states are involved or are not involved, or they should be involved.
Thank you so much. Okay, we have now Francesca.
So thank you very much, Tom, for your comments. I will try to be very brief because I would like then to clarify some points in the extended paper. I don't know why I would be through these focus group, which I will be more than happy to in other contexts. But in any case, so the first point you made, I also noted it while rereading and preparing the presentation, because there was also, I think, a discrepancies in the paper, and I would like to dig into it also, especially before the COVID-19 pandemic and the discussion that was raised about the health passports. Because the reference I found it, I mean, the prohibition of controlling and of having this sort of health passport, I retrieved it from the International Health Regulation of 2005, but I would like to go back to it and read it again carefully because I'm not sure about. I mean, I found some exception because the regulation itself referred to exception about people that wanted to ask for a resident, permanent or temporary residence permit. But I think I will retrieve more information while digging into all the discussions regarding COVID-19. So I would like to dig it more and to see how much states can control health, in which terms, in order not to undermine also the international traffic. This was I think the need to balance both needs. And the second point, the delegated act, as before joining today the conference, I don't think it was published. I will check it again, but I have not found it in the official journal. I will check again. Those have been adopted and not published, unfortunately. Sometimes it happens. Risk indicators. Yes, there was this reference to the fact that risk indicators should not be based on sensitive data. How they selected which criteria, that's a very, very important point. At this stage, I don't know it because I think probably it could have been the agency inside, or also if they externalize and maybe are helped by an external contractor, it could have been made together with them. But the point is that, okay, I imagine your point, which is, yes, but we are dealing with fundamental rights, no? So it's not clear how to select, why to select some indicators based on sex instead of other sensitive data. This could be raised as a question mark, but I'm not sure that it has a clear answer, straightforward. Anonymization and pseudonymization. And the possibility, it was the EDP, yes, if I'm not mistaken, actually, that issued these, that raised this point, meaning he warned that despite the benefit of synthetization, we should, in any case, provide for an impact assessment based on fundamental rights and not, let's say, to be blind on the fact that synthetic data are not, do not interfere with privacy. But I think that the point of how the impact assessment is done, we are all debating about it all the day long. So it relates also on the AI Act, whether it is going to be only a tick in the box or whether it is going to be something more. Probably Frontex has, I hope, and for sure he has his own data protection officer, and I think it is that office that handle all the questions related to that. And I don't think maybe Niovi can help. I don't think it's in any how connected with the EDP. I mean, they for sure relate with the EDPS and EDPB, but I don't know how much there is this relation between the agencies DPO and the EDPS and EDPB itself. I have no idea. And the last point, yes, the last point is the question mark I also made, because reading some literature also on clinical data and on the right of the patient not to learn and about his health state or about a specific disease, I found interesting the fact, interesting and scary the fact that actually here the person will know maybe that he's carrying some sort of disease, which he was not aware before. And also because I had not time to mention, but the person could be asked to bring some certificate also in case there is a hit against the risk indicator. So in this case, it will have go through maybe a medical check, and this is going to be tricky to also to manage this part. I don't know how far the Commission is going in this sense.
Thanks a lot. Thanks, Francesca, also for adding further question for Niovi, and thanks, Niovi, for being with us for the whole panel. So the floor is yours.
Thank you so much. I will keep my comments very brief because I really have to go very, very soon. Thank you so much for bringing forward parts of the paper that I didn't have the time to elaborate, including the emphasis and the importance of the logs and the difficulty to do supervision on the basis of logs. So the idea that AI could be used actually by supervisory authorities in order to do the supervision comes from the way that supervision takes place in financial markets. And what is called subtech gave me the idea that actually this is already done in another sector and actually could be replicated as a model for future supervision of how processing takes place also in this field, with all its problems that it can create, whether these AI systems can be reliable, but it could be a way in order to monitor better data flows and follow the pathway of the data from its genesis till its deletion, including when AI is used in order for the data to be processed. And finally, as for the AI Act, it is indeed one of the major problems that we had whilst the AI Act was negotiated, the extent to which it created a divide between databases, which are EU-wide, from the AI systems that are purely national ones, by saying that the EU systems will only be subject to the provisions of the AI Act by 2030. This was the final text. At the beginning, things were even worse because the AI Act actually said the AI Act would not be applicable to the large-scale IT systems until the legal framework would change substantially. The European Parliament wanted to bring them immediately within the scope of the AI Act. The compromise was to have this gap. Hopefully the gap is going to, the idea is that interoperability will be fully functional by 2027, creating indeed a 3-year gap whereby the AI Act will not be applicable. The reason why this is the case is because interoperability and the databases started being created before the AI Act, which means that a lot of the safeguards of the AI Act were not embedded when these systems were conceived. And that's why in order to make them work, since the process of creating them has already been set in motion, they couldn't be subject to the AI Act, which is also an admission of fundamental rights problems. The fact that impact assessments were not done at the beginning for ETIAS or for VIS, the fact that AI was not even mentioned. All these create a very blurry and obscure framework, and I fully agree with you. This is a terrible problem but hopefully this will be sorted out on its own with supervision over the next years. I really have to go. I'm really sorry that I will not be able to answer anything else, but the paper is available. Please do not circulate. It's still subject to review, and I look forward to receiving your papers as well and continue this discussion elsewhere. Thank you.
Thank you. Thanks, Niovi, and have a nice continuation of the afternoon. Ciao, ciao. And thanks, everybody, for this fruitful discussion. We have now to move to the second panel, running a little bit late, but I am confident we will make it on time. And meanwhile, I also want to say hi to Julia. I see you connected. It's great to have you.
Hello.
The last one anyway, so I mean.
Okay, so I have enough, but I think 2 hours. So okay. Okay, welcome everyone to the second panel of this workshop. The second panel is titled Automated and Data-Driven Decision-Making in Migration, Asylum and Citizenship Policy. Let me introduce to the first speaker, Rohit GUPTA, from the Center for International Law Research and Policy in Italy, who will present a paper titled From Fact Work to Fact Synthesis, Quality Control for Predictive Models of Humanitarian Action. So the floor is yours. I think I have your PowerPoint.
Yes.
Great. So let me find it. Yeah, I think you just need to scroll down, right?
Well, good afternoon, everyone. My name is Rohit Gupta, and I'll be your coffee break this afternoon. But jokes aside, I'm a fellow at the Center for International Law Research and Policy. And the paper I'm presenting today deals with fact synthesis. This is a term that I'm proud to have come up with. And I define it in relation to fact work, which I'll just define in a moment. But essentially, it deals with the processes of predictive models of humanitarian action. What this means is that technology now exists using artificial intelligence and machine learning, which can predict how and what humanitarian crises will occur and allow us to prepare in advance and disperse humanitarian aid so that we can better deal with these processes. Now, right before I start, I just wanted to draw this dichotomy between these two pictures that you see on the left and the right. The one on the left is this beautiful painting I saw 3 weeks ago in The Hague. It's 17th century work by Albert Quaid, and it describes migrants moving in a southern landscape, and of course, it's extremely pretty. And this image is what I was reminded of, which is a 2019 image of Rohingya refugees being forced to migrate from their homes in Myanmar to Bangladesh. It just made me think of how reality is not really as pretty as our ability to make it. And I think that we should all remember this while we discuss the more technical aspects of the paper. Oh, it's all right. So back to fact work and fact synthesis. So fact work as a term also comes from this book that I've posted up here. Is also the intellectual work of the Center for International Law Research and Policy. It essentially deals with the systematic establishment and verification of facts. It's done by UN agencies and NGOs, essentially to tell the truth about armed conflicts, humanitarian crises, and to establish and help mechanisms of accountability. It allows us to legally classify what happened and look at avenues of responsibility, essentially. But when I move to talk about fact synthesis, this is a process where we're sort of generating facts. We're coming up with new predictions and insights based on fact work. And it allows us to inform decision-making in mitigation, preparedness, and response. So essentially, we're taking 2 steps forward to go 3 steps back in terms of humanitarian action. And this is what leads to anticipatory action, which is acting before the crisis strikes, essentially. This is not something that's new. We already know of weather forecasting, and this has been done for years now. In fact, in 2020 and 2024, there was aid that was dispersed, almost 12 million to Bangladesh in prediction of severe floods. But again, what my paper talks about now is not weather forecasting or the forecasting of natural phenomena, but forecasting of social phenomena and like human behavior. This comes with its own issues and quality control problems that I will shortly discuss. Very briefly on predictive models. These predictive models exist. For the purposes of this paper, I will be focusing on models that relate to migration and that predict migration. But these models also exist to predict, for example, they were used to predict COVID-19 outbreaks, used to predict armed conflict. And essentially what they deal with is a model which uses machine learning or other types of AI modeling, and it produces a result which can trigger a certain threshold that is pre-decided, for which a pre-decided financing plan is put in place, and then we have an action plan that is executed. And that is essentially what the process is. We know that one such model is the one by the Danish Refugee Council, which is the foresight model. What that does is it looks at 120 indicators, 120 different data points, and predicts 1 to 3 years into the future. And it predicts the total number of movement that will happen in a country. All these 3 indicators are very important. What are the data sources? What does it predict? And how much in the future it predicts? And this is essentially where the issues will come up, and I'll deal with it in just a second. But just to give one last piece of context, which comes from the main case study of my paper, which is Project Jetson by the UNHCR. This is a project that detects 1 to 3 months in advance what are the internally displaced people and refugees moving within Somalia and in Ethiopia and at the southern border. And the reason why you see this goat here is that an interesting story came out of Project Jetson, where when they were deciding which data sources to use to improve accuracy, they conducted some interviews with the villagers in Somalia, and they realized that villagers would, before migrating, sell their goats, driving prices down because supply would increase. And in the places that they would migrate to, they would buy goats, increasing the prices of goats. That's where they realized that they could actually use non-traditional forms of data, which were more human-centric and gave a more ground-level picture to sort of improve the accuracy of their detection itself. And this leads me to the main heart of the paper, which are the 4 operative functions that are relevant to predictive analytics when we talk about migration. The first one being what data is collected and produced. So data selection is extremely important because it informs what the actual prediction will be. For example, the Danish model, which is the foresight model, does not collect ground level data, which is why it's also not able to predict in advance situations where there is a sudden onset of mass displacement. It deals with historic data and more gross and systematic data, which is why its predictions differ from the Jetson model, for example, which deals with much more ground level data. In fact, it also deals, data could also be of social media character, and that could also help us gain insights into what local communities are thinking, what type of locations are they thinking to migrate, and this is some of the information that can be extracted based on the type of data that is selected. That's an important concern, and one that I will deal with in the paper to sort of classify how decisions can differ. Another very important aspect is what is the mandate of the model itself, whether it is feasible given the geographical scope, whether the output is specified. So for example, in the foresight model, they only delineate the volume of refugees, but they don't talk about where the influx or outflux will happen or what is the timeline for it in a granular format. And again, if the idea is to disperse humanitarian aid quicker and more efficiently, of course, we need to understand as granular as we can. But this again creates its own sets of issues. For example, When we look at the differences between, for example, when we look at the differences between Project Jetson and the Foresight model, we notice that for the Project Jetson has much more granular data, and it can also look at issues, say, for example, on gender data and how much of the population percentage is women. And of course, that would inform the decisions of humanitarian aid in a much more different way than what could be informed by Project Foresight, by the Danish Republic, which does not differentiate between what type of individuals are moving, whether they are male, female, what are their needs in particular, and that sort of creates its own sets of issues. On the second operative function, which is how the data is collected, it's also important to see whether data is collected based just on fact work done by other organizations, like what is done by the Danish Council, or whether it's like Project Jetson, where you are conducting ground level operations yourself and where information from civilians who might be affected are collected. And this again produces different results, as I've just spoken about. The third and the fourth operative functions are extremely important. And this is because it is important to emphasize that predictive analytics models are based on correlation and not causation. But as the accuracy of these predictive models increase, we can envisage a situation where it increases to an extent where it could be used as evidence in investigation or casework, or it could inform legal classification of situations. But this must be informed against, because the AI model essentially only delivers an information that it is feeded in, which is why it's important to take into account what is the point of the model itself, to what end does it serve. It serves as a tool rather than as a standalone classification of the situation itself. It's not supposed to give us insight into what causes what incident, but rather that an incident will be caused based on several network of correlations between data points. Finally, the question is in what form and whom is it available to? And this is also a very important point, which ties back into what is the statement of output? Is it one that has a legal or political character, or is it one of merely a statistical nature? Because this also affects how the access that the organization creating the predictive model has with relation to the government from which it seeks data. So this would also harm their own purpose if it is if the statement of result is one of political character or legal character. And it's important to sort of make that distinction when we talk about this. It's interesting to note also that this is actually precisely why the Project Foresight deals only in a much less granular manner, much general manner, to delineate how many people will move from one place, rather than the location or what type of people or their timeline in itself. Because it's also predicted, and this is something that I discuss extensively in the paper, that prediction models could be misused by governments to inform anti-immigrant policies, and especially in the European climate, it's very foreseeable that it might become an election issue and might drive sentiments against immigrants and might drive policies and border closures. Again, I am not entirely sure, and I would answer in the negative as to whether this is something that that predictive models should necessarily consider, since their usefulness is also affected by it, because we understand that the Project Foresight cannot be as useful as Project Jetson might be in terms of granularly assessing what humanitarian aid must be dispersed, how much, and to where. But this is again a decision and a balancing act that must be conducted. Okay, just on the last side, these are some of the quality control frameworks which will guide my assessment of these issues that I've laid out. In essence, these relate to the principles of do no harm, and again, regular criticisms of artificial intelligence, which deal with transparency, explainability of the output from an artificial intelligence model, the availability of data, and also data privacy, etc. And I can discuss this more in private. And that basically brings me to the end of the presentation. Again, it's important to emphasize that the paper talks more about the issues, and the point of it is to raise questions rather than to provide solutions, because like we just discussed, it's not something that social scientists can do alone. This type of thing must happen in collaboration with data scientists. It's not the job of one entity or the other. But very importantly, and it is my hope that my contribution here can at least give us an indication of where to look at for the questions that need to be asked. Thank you.
Thank you for such an engaging discussion. I'm a bit concerned with the time, so I think as we are going to have plenty of time for discussions and questions at the end of the panel, I will move directly to the second speaker of this panel, Agnese PALAZZI from the University of Bologna, who is going to present a paper titled Navigating Complexity, the Intersection of Artificial Intelligence and Refugee Status Determination in the EU Legal Framework. I have your presentation. Okay, so let me find that.
It's Palazzi, the one right after over there.
This one?
Yes.
Ah, yes, sorry. This is
No, no problem.
right. Let me close. This one. Yeah, I think
And
you
you
just
go, it's changes just this one, right?
because you sent it in
Yes,
PDF.
that's true.
So
maybe, this,
you just have to press here.
okay. Thank you very
Here or there, yeah.
much. Great. Thank you. Okay. So, good afternoon, everybody. Thank you very much for this opportunity. I'm Agnese. I come from the University of Bologna, and this paper I'm going to present is part of my broader research in my PhD thesis. I would like to bring you with me in my research, trying to navigate the complexity between the use of AI into the refugee status determination process in the EU legal framework. To do so, this is more or less the table of contents we're going to see today. We will shortly introduce the scenario, the background information, the research question, and then we will see some practical examples on how AI is nowadays used by EU member states during the refugee status determination process. And then we will try to see which kind of safeguards are provided by the EU AI Act. And we will try to address the main question behind it. And then we'll try to draw some conclusions, but I would say most of all the open questions. So the background information is, as you know, AI has started to be used as a growing tool to manage a vast amount of information. Of course, member states see in AI as an opportunity to enhance efficiency and modernization. This is also the case for asylum, migration, and border control. Several states have started to use AI into their public administrations in order to face the rise of asylum applications or migration flows that in recent years have confronted them. But the question is, how does AI impact the right to asylum in European Union? And which kind of safeguards are provided by the EU AI Act? Well, to answer this question, we'll need, first of all, to see how the member states are using AI into their asylum procedures. We see from this slide that several member states are using AI tools in different ways, starting from case management, so for administrative and management purposes from one side, but also to support the decision-making. In which sense? We will take as an example coming from Germany, which is the voice and dialect recognition in the asylum procedure. How does it work? This is an AI tool which actually is proposed to Arabic-speaking applicants, asylum seekers. So just before the interview of asylum, the applicant is asked to describe a picture. This description is then recorded by the AI tool, And the AI tool is able to associate the pattern, the language spoken by the applicant, and identify the accent and the language spoken by the asylum seeker. For which means the purpose is to elaborate a report, an automated report, which is added to the asylum application and which aims to support the authority in the country of origin assessment. As you know, the country of origin assessment in the framework of the asylum procedure is extremely important because on the one hand, it supports the authority to do the operation of the credibility assessment, but also it allows the authority to elaborate a correct risk assessment in case, of course, of return of the applicant. So we see that in this case, this AI tool is used for supporting the authorities to create an evidence and to support the evidence assessment. I'm sure that this example raises many questions in your mind while I'm speaking, but these are the main questions I would like to point out. Of course, this kind of tool may raise some question concerning the invasiveness. No, can the applicant refuse to go to be used, to be recorded, and then to be asked to undergo this kind of examination? Is there a risk to privacy, to data protection? Are the outcomes provided by the AI tool accurate? Can we rely on them? Are the data on which the AI tool trained biased? Is there any risk for discrimination? And how can the applicant challenge the results and how the machine tool? This is the reason why we need a robust legal framework to ensure the protection of fundamental rights, especially in the case of asylum. This is when the EU Act becomes problematic, becomes relevant. As you know, the European Union had just decided to adopt the first binding regulation concerning AI. So until now, until last July, AI was not regulated. The use of AI was not regulated into the EU legal framework. From July on, and the different deadlines for its implementation, the use of AI will be regulated. Of course, the purpose of this regulation is to ensure a high level of protection of fundamental rights, as stated in Article 1, but also it includes a very broad definition of AI. In order to stay up to date as much as possible to facing the development, the technological development we live nowadays. It also uses a risk-based approach. So it identifies some risks, and according to the risk, stricter or less stricter rules are applied. As Professor VAVOULA was anticipating before, what is in the case of asylum, migration, and border management, the EU Act sees that those systems, the systems used in those fields, are classified as high risk. So for us, let's say, it's a good news, okay? So normally, in theory, the stricter rules will apply. However, in my opinion, and from what I heard just before, it's not only my opinion, but the EU Act presents some pitfalls, specifically in the field of migration, asylum, and border control. So we have the question of classification. What if the system used in asylum, migration, and border control won't classify as high risk? Which kind of discipline, what kind of rules will apply? Will be there any kind of possible safeguards to fundamental rights? Because in fact, Article 6, paragraph 3 provides several exceptions to the normal rule of identification and classification as high risk. But it's not only it's not just this problem. Even if the system is classified as high risk, the EU Act provides also several exceptions, especially in the field of asylum and migration. And this exception, which of course today we don't have the time to go deep into that, of course, raise other questions. Why in this field we don't need this kind of guarantees? Which kind of safeguards are possible to foresee for asylum seekers and also for the rule of law or rule of law in this field? So jumping to our conclusion, we can, from what we just saw together, we can draw some main points from this specific topic. EU member states are using AI tools. How they are using it? They are using it not without protection-oriented purpose so far, but mostly to support the authority in the evidence assessment, which creates a lot of problem from a legal point of view. We have the question of efficiency on one side, and on the other hand, on the other side, we have the question of protection of fundamental rights. For sure, the EU AI Act represents a good point, because so far, until this summer, the use of AI was not regulated at all. However, we cannot say today that it is a good news in definitive terms, because as we saw, there are many exceptions which apply with specific reasons to asylum. So the open questions are there. What will happen? Which possible guarantees we can foresee if AI in asylum will not fall under the classification of high risk? If classified as a risk, what are the possible consequences if in presence of those exceptions provided for this specific tool? And which possible interaction with other legal provisions such as the GDPR, but also the European Convention that just adopted some days ago by the Council of Europe, and on which the European Union decided to sign it. So that we have an evolving landscape that I think that as asylum lawyers or migration lawyers or asylum scholars, legal scholars, we need to become aware and try to keep an eye on what is going on, keep an eye on AI, but this is another story. So thank you very much. I'm looking forward for your comments and questions and really on feedbacks. Thank you very much.
No, thank you so much for such a great discussion. I'm gonna now hand over to the third and last speaker of today, Riccardo VECELLIO SEGATE from the University of Groningen, who is gonna be talking or presenting a paper titled Biometric Technology at the Borders of Citizenship, Identifying Technical Standards for Introduced-Based Remote Onboarding in Global Context of Statelessness, Nomadism, Displacement, and Refuge.
These are just the titles. So it's
Yeah.
the slides, right?
Yes, I do, but let me. I don't think I can open them.
Just open we and then open we. Yeah, those.
I don't know why.
I think it's down there.
No. Let me try again. Okay, perfect. Yeah. So if you just press here, then you'll be able to. Yeah.
Okay.
Yeah.
Right. Okay, so thank you very much. So I'm Riccardo, I'm Italian as well, though I spent most of my life abroad. as too many Italians are forced to do. I'm currently with the University of Groningen in the Netherlands, but this work is also was also based at the Alan Turing Institute, which is the UK's National Institute for Data Science and AI, which means that it's a place where you find engineers, data scientists, and computer scientists, and you don't find, on average, lawyers and experts in ethics, which is absolutely fine, but it's also challenging when you, of course, are asked to foresee problems that are not yet there in order for them to conceive of technology solutions that might impact situations on the ground. Usually lawyers, come at a later stage and say, well, okay, this is not compliant, this is compliant, so on. But in those places, you tend to do things by design, which is much harder because you have to imagine situations that have never been addressed before. So at some point, I also started to study engineering, and now I'm halfway through. So yeah, that's part of the story. So this paper is part of a research stream funded by the Gates Foundation on borders of citizenship, so identifying technical standards that can work, especially to onboard people's identities, so to record individuals whose identities are known to the state. Now, of course, in doing so, there is an imperialistic agenda behind, which I shouldn't be saying, but it's kind of obvious. The problem is how to keep this thing alive, because that's where the money comes from, and at the same time be fair to the people that are the eventual, users of these technologies. In any case, there are globally from 600 to 900 million individuals whose identities are known to their state, to the state where they are physically located anyway, which is a big issue, and most of them can be included, they fall in one of those 4 categories. So they are either stateless individuals, they are nomad, they are displaced, internally displaced, or they are refugees, or at least asylum seekers. So this is an article that I published recently that actually got published sooner than expected. And, the presentation is based on these articles. I will just extrapolate a few ideas therefrom. Of course, in the background, what's really interesting is this idea that public international law tries to provide the tools to solve certain situations at the borders, but borders themselves have been created by public international law. So for the longest time, nobody has ever needed even the concept of the biometrics, for the simple reason that there was no possible enforceable borders. There were borders, but it was impossible to enforce them thoroughly. So public international law in this project becomes something that you have to manage carefully, because yes, it's a provider of legal solutions, but before giving you the tools to address things legally, it also creates the problem through law. And the segmentation of the planet into border areas is really a public international law concept itself. Now, again, borderline citizenships. So these 4 categories of people really at the borderline. Now, well, I guess we all know what refugees are, so I don't need to go through this slide, for example. When it comes to stateless individuals, I think it's very important to note the distinction between de jure statelessness and de facto statelessness. So the fact that a citizen might really have, an individual might really have no citizenship at all, okay, and that is de jure. But also de facto, there are a lot of situations where the state should know that that person is a citizen, but for some reason it doesn't know, or it forgot along the way in many possible ways, more or less, legitimate. And that is a situation of de facto statelessness. And this, of course, has a tremendous impact on individuals because they are placed outside of any legal regime of protection. Though, of course, when you try to address this, then the other side is that, okay, well, if they've always been living in peace, why should you reach out? And, it starts with all the usual stories that we tell ourselves in humanitarian assistance and so forth. So this is, again, a very contested area. Also, sometimes, relinquishing citizenship is voluntary. So what do you do in those circumstances where people relinquish to an identity and don't want you to enroll them into some other identity? I say some other identity because there are different types of identities in life. One, is formal, is official, is the one you get at birth, and it's called foundational, at least in computer science, when they try to devise, schemes, protocols for addressing this. This is called foundational identity. But there are also functional identities that you can reassign later. And so one might say, okay, well, you relinquish citizenship. I still want to know who you are. So fine, you're not that person anymore because you relinquish that identity. I give you another identity, which is functional. Should we do that? I mean, relinquishing citizenship is arguably a right. I'm not sure whether we can really say that legalistically, but in any case, this is also an issue that you face. On the other hand, states are under an obligation, a positive obligation to reduce state level. So even if individuals don't want, well, the state might say, well, I have the obligation to enroll you somewhere, for example, in territories under de facto control. So when it comes to international humanitarian law, states have an obligation, a positive obligation to enroll individuals. They tend to do it not for humanitarian reasons, but, well, that's the situation. Nomadic populations, there is little to be said, beyond what we all know. I distinguish between traditional and digital. I got a lot of criticisms for that because they say, well, but your whole thing seems to be around humanitarianism and so forth, and then you place the digital people there. Well, but digital nomadism, we tend to think about the super rich who travel for, and work as software developers from Hawaii, etc. It's not only that, okay? There are a lot of types of digital nomadism, and not all of them are necessarily within the 1%, the ultra high net worth individuals. So we have to be careful not to simplify our assumptions. Internally displaced people, it's very interesting what I found, within this Human Rights Council documents, that they basically said, one reason why there is a positive obligation on states to ensure that internal displacement doesn't turn into human trafficking is not only the protection, of people's dignity and so on, but also the protection of their identity. So this seems to be really a topic. I'm going very fast, but this is already explained at super length in the paper in a very legalistic form as we love it. And obviously, all of these are multimodal phenomena that are on the increase. They are called propsy, asymmetric, whatever. In any case, this is really a phenomenon that in number, but also in quality, tends to become really, really noteworthy nowadays. For a number of reasons, including what we call fragile or failed states. So all these, domestic entities that exist on paper, but tend not to be able to control what the population does, including when it comes to know who the population is is made of. Okay, now who is the introducer in all of this? Because I've never mentioned this so far, but the entire project is about building machines that can enroll your identity. But in many cases, of course, you can't just go there and build some machine and expect people to go there and deposit their fingerprints or their voice biometrics or the iris or whatever. You need a lot of mediation if you want to reach that goal. And that mediation is made of other human beings. And other human beings are called introducers. So somebody who can vouch for your identity, who knows who you are. The state doesn't know. They know. And they tell the state who you are. So they need to be trusted by you and by the state. And these are called introducers. Now in asylum only, introducers are those who are trusted by the state, okay? And they are appointed by the state. But when it comes to this work, I understand it more broadly in the World Bank sense. So people who can vouch for somebody else's identity and is trusted by both. And this builds a bit on what India has done. I forgot to anyway, what India has done with Aadhaar, right? An enormous enrollment mechanism by which dozens of millions of humans have been, enrolled into a system, and the state for the first time realized that there were other people around. In the end, what matters, not in the end of the presentation, unfortunately yet, but in the end of this part, what matters is that there is no guidance at all. I mean, whatever document you try to find in international law, broadly conceived, even soft law, whatever thing we put under this label, you will never find anything about the introducer, apart from the asylum system strictly understood. So this is, I mean, novel work, but obviously it's mine, so that's why I say it. But novel in the sense that the problem has always been there, but nobody has ever cared. The problem is that the World Bank has said, no, wait a moment. So this is really becoming pressing ones, and we need some legal framework. So the research questions were, okay, how to trustworthily onboard people. Trustworthy means, how can I trust you? I mean, how can I trust what you're telling me? Okay, so how can I trust the introducers? How can the introducers be trusted by the people, and the people by the state, and the state? So there are all geometries of trust that are at play here. So beyond lawyers, I would say. Who are in the introducers? So what is their function? For example, in Nadar, there's been a lot of mess about the introducers because they at some point they were held liable for mistakes, and so they stopped doing the work. If they are not free to make mistakes at some point, why would they do that? So liabilities are also very hard to convey in certain areas that are remote and where things are more informal. Okay, the structure of the law is more informal. And finally, the last two questions are the hardest for us lawyers. That's why I started with engineering projects. Designing technical standards. Now, technical standards really are the cornerstone of tomorrow's regulation. Nobody cares about the law in many circumstances, especially on the ground. Anything that we can try to make work is in the language of standards, technical standardization, which is obviously a problem because nowadays it's a widely self-reflecting area where every agency does more or less whatever they want, though their power is increasing. And IEEE, ISO, but there are many at the domestic level as well, and they wield an enormous power, which is basically unchecked. The EU starts doing something with the harmonizing standards, but most of these anyway are American, and most of these come from the banking sector. So the European Commission is not going to catch these agencies anyway. Okay, so when it comes to nomadic population, there are a lot of things to care about if you need to build a system to enroll them. One problem is, of course, to find a minimum core data sharing across all the jurisdictions where the people transit from and transit through. And this is really specific to nomads. I have to go very fast, so I'm skipping most of this. But again, this is really, really lengthy in the paper itself, so no worries. Refugees. Well, refugees, I would spend a bit more, a few more words on this. It's really, really complex. It's really, really complex. Now, the paper was also criticized a bit by the UNHCR because they say, well, in the case of Myanmar, for example, you just sold the data to the destination, to the country of origin, and this is something that if you want to enroll people, you shouldn't do at all. And they replied, well, we actually haven't. We just shared the data with the destination country, so with Bangladesh. And then, if Bangladesh said back to Myanmar, who fled the country, it's not our fault. Well, I strongly disagree. This is a legalistic argument which makes no sense. If you want to protect refugees, and if you want to make sure that when you onboard somebody's identity, that identity does not tell the persecuting government who among those they are persecuting is fleeing the country, well, you have to make sure there is a memorandum of understanding in place and enforceable, by the way, that doesn't make the destination country share the data with the country of origin. Otherwise, the persecution, is just back to the back door, basically. Some refugees will be turned back, others will be catched in the new country anyway. So this is really important. And then, of course, the problem lies with the identity of these introducers. Diasporas in the destination countries, of course, they have their own fears. They don't want to speak with the authorities. They don't want the authorities to know that their English is not, or whatever, the language is not good enough, and they might be checked anyway. The country of origin is even worse because, of course, they might be part of the same persecution, group, Or there might be a regime change. So it's hard to track exactly what kind of group would be safer to introduce, the people who fled and so forth. So there are a lot of issues with the identity of, these people. Statelessness. When states are asked by an individual to be readmitted within the community, so to re-become a citizen, one of the things that they assess is the good character. So of course, here it becomes very difficult to identify the right introducer again, because the introducer is going to be seen as a sort of scoring person, somebody who's going to rank you against some external criteria, or at least to give you a score. And it's not what the introducer is really for. The introducer should be a person who is trusted with this delicate task, without be seen as an agent of, as an emission of the authority of the state. So we are back to the problem of, the delicate balance of trust there. And displaced individuals, again, for example, here we have guiding principles and so forth, but there is no guidance at all. And in the case of local displacement, so when we say internal displacement, one can say, well, okay, introduction should be as local as possible. In theory, yes. In practice, no. Why? Because internal displacement, a lot of time, yeah, sometimes it comes from natural hazards and whatever, but most of the times comes from man-made disasters. And guess what? Most of those man-made disasters come from corruption, infrastructure, construction bias, which are all local. So probably a few of the people who were involved with these mechanisms should not be the same who introduce others at that level. So there is there are a lot of problems to be solved, even if the situation is really, really local and internal. Now, I will just conclude very, very briefly with two considerations. One is on the nature of technical standards, and the second is an example of things that you don't think about, but then when it comes to advising computer scientists on what to do, you need to take into account. Technical standards. Now, of course, there is a lot of literature on technical standards as a sort of regulatory channel beyond the control of positive law. And I would argue it's part of a more general trend towards the outsourcing of regulatory action. And if you think about it, there are a lot of examples. Take patent offices. Patent offices where people not trained in this kind of bioethics questions ask, for example, the boundaries, they decide the boundaries of patentability between certain things that might be neuroenhancement or, neuropsychiatric pills. So this is just another example that I just published about this. I put it there, but there are many examples of the fact that there are a lot of areas that tend to escape the control of positive law or the institutions that are supposed to deal with it. And the more technical and the more into bioethics questions or engineering intensive questions we go, the more this happens. So this is part of a broader trend. That's my message. The second is the example, and with that I conclude. So there are many more examples in the paper, but this is the simplest one. Think about internet, okay? Of course, all these things need to be done through cognitivity. So people on the move need to have means for digital onboarding, which is remote, okay? And of course, you might just, tell them to use the general internet. This is not going to work. Not just for matters of coverage, but mostly because anytime there is an issue, as we know, authorities tend to switch off cable-delivered internet. All the time that there's a protest, the people escaping in mass, etc., authorities in certain authoritarian states, but not only authoritarian states, and part of them tend to switch off the internet. Now, this is partly solved through satellite-delivered internet. I say partly because, of course, it's also delivered by somebody. So if that somebody is, a strong geopolitical ally of the dominant power, for example, Starlink with the US, etc., you're going back to the same problem. But let's say that conceptually, you have to also consider all the possible ways of delivering the internet. It's more expensive, it's slower, it will be disrupted by the weather, whatever. But at least authorities will have a harder time switching it off. So this is an example of the things that you need to consider when you advise computer scientists and engineers on these kind of questions. All right, I think it's all from me. Yeah.
Thank you so much, Riccardo. I need to move quickly to Sissy, who will lead the discussion and the question and answers, but let me stop sharing the screen first. Answer. I may ask perhaps the speakers to sit a bit closer. So the speakers are not close.
So thank you very much for giving me the floor, and good afternoon from me as well. I know you haven't heard from me already, but I'm also a member of the coordinating committee and a newer one, along with Julia, who's attending online, and I'm really happy to be here for my first in-person workshop of the interest group as a co-convener. And I'm very happy and I feel very privileged to have had the opportunity to read the papers that you sent us because they were all insightful. And I just wanted to get this out of the way already. We will have a symposium in cooperation with the Völkerrechts blog. And in this context, we will provide you with the opportunity to share your research papers in the form of a blog post, however, through the Völkerrechts blog, so that others will also have the opportunity to get access to this valuable argumentations and the points that you shared in your papers. We will approach all of you in due course with this. I just wanted to announce already that you can reach out to that. You can expect to read these contributions in the form of a blog post as well. And with that having been said, and in the interest of time, I would just like to perhaps address a little bit of some preliminary questions with the speakers, and then open the room for any remaining questions from the audience as well. I guess I would like to also start with Riccardo. I hope using the first name, proceeding with a first name basis is okay with you. So I would like to first start with Riccardo and to build on what Tom mentioned earlier today on the lack of academics presenting in this interest group from non-Western countries, let's say. Because you mentioned in your presentation that the issue, that the problem that you presented has been raised by the lack of enforceability, let's say, of borders. But I was also thinking that perhaps all this issue has a reason from the fact that refugees, protection seekers, and generally and stateless persons, of course, are nomads, or all the other types or categories, or all the other persons that you referred to in your presentation have not been included in the discussions during the about the regulations or guiding principles, or any form of regulatory document that has been made or will be made in the foreseeable future. So I was thinking, is this additional research that you refer to in your paper indeed a panacea, or is it just, let's say, an intermediate step until the international refugee law and protection under refugee law is reconstructed in total? Perhaps we will see something on this in next year's interest group, but I wanted to hear your thoughts.
Yeah, that responsibility on my shoulders.
Well, second, I wanted to address a question to Rohit and Agnese. I think this question, it's one question, but I think it is suitable for both of your publications because of your paper, sorry, because I noticed that you mentioned, both of you, transparency and the importance of some transparency in law enforcement and migration management that uses AI and in predictive models. So I was wondering, what type of transparency do you envisage? Because when I think of transparency, I mean, usually when I receive, for example, an indication in my phone that my data will be used somehow, I immediately click accept. I have no idea what I consent to, but because it is phrased in a manner that I cannot understand, considering that I don't have the technical knowledge to really meaningfully consent. So I was thinking, yeah, what your thoughts on this are. And of course, I will open the room to discussion and to anyone else's comments and questions if that's of interest. Thank you.
Yeah, we still have 10 minutes, so if anyone from the audience wants to pose a question to the speakers, the time to do so. Okay, so maybe
Yeah.
we're gonna.
Yeah, maybe,
Okay.
is there anyone from the floor?
Do we have any? I will also check Zoom because I saw a comment there at some point.
It's from before.
Ah, okay. All right. Sorry.
The one from the audience?
No one raised it.
Okay, okay, yes. No, I just wanted to thank all the presenters of this second panel as well. I would like to comment on Agnese's presentation, because this example you made about Germany and the way in which credibility assessment is inferred from dialect is quite astonishing, and reminds me of also the way in which interviews are conducted for family reunification in some European member states, such as, for instance, in Denmark, where people are interviewed from the country of origin, and they have to answer questions which are posed by an AI system, and in that case, it's also not much to detect the pronunciation and the dialect, but to see whether the person is able to understand the constitutional norms and the habits of the population, the host country. It's quite astonishing, but it goes in the direction of automation of these processes, and I would like to hear a little bit more about the possible impact on non-discrimination, and also whether those tools are designed in order to respond to differences, to intersectional issues, and so on and so forth. Thank you very much.
So you want to go first?
So reaching out to the right target, yes, with a caveat that, of course, part of the reasons why we don't reach out to them, of course, is an excuse, is their unreachability. But another side is really that there are certain categories of humans that we put into this, under these labels, like asylum seekers and so forth, whose rationale for moving is precisely not to be known, or at least not to be known in the way they were known before, which is essential to their safety or survival or both, and or even well-being in a broad perspective, etc. So do they really want to be reached out, and especially to be reached out in a way that becomes formally channeled into a regulatory process? I don't know. I mean, nomads might be internally displaced, yes, definitely. Certain categories of migrants, of course, digital nomads, will fine. But when it comes to asylum seekers in certain circumstances, I think that there is, a problem of legal methodology in doing this. I mean, are we doing legal ethnography? But if we do legal ethnography and we hear their views informally, then we need somebody to translate this informality into a regulatory process, and they are not going to feed into the regulatory process themselves as members of the process. They are not going to be part of those committees anyway. They might be, they might not even be observers. They are just, heard people or people you collect data from or you hear the story of. Is that going to be trustworthy? I mean, you will anyway have a lot of mediators. And if we come to that point, then we already have a lot of that because we already have a lot of legal ethnography, including by myself. So there is no lack of literature on what migrants say they want, but say to us. But then it's hard to tell the committees. And so, but would they want to fit into the committees? So, it's part of this, again, and with this I conclude, I think part of this is an excuse that we tell ourselves to feel good and to move on with our years as usual. But how much is that an excuse and how much is that real? Because a lot of people I talk with, unfortunately, I put them in further trouble. And sometimes the trouble is little, other times the trouble is enormous. And so you put people in a situation that you don't want to multiply.
Okay, so thank you very much for your questions and observations. Sorry, I don't want to turn my back. Okay. Because it gives me the opportunity to elaborate a little bit on some points that, of course, in 10 minutes it was hard to feel it. Starting with the question of transparency. When I was referring to transparency in the presentation, and when also the law talks about transparency concerning AI systems, it refers on the data on which the machine have been trained, but also on the explainability of the reasoning behind the outcome. One of the questions of AI is that there is this so-called black box. We cannot really understand how the machine arrives to produce a certain outcome. And why it is relevant for us? It is relevant because in legal terms, it could be referred to the obligation to motivate. When there is when a judge issue a decision, the judge is obliged to motivate, explain the reasoning behind his or her final decision. Is it the same for AI? So far, until the EU AI was not required to give an explanation. With the EU AI, they tried at least to establish some safeguards in order to a little bit ask not the same level of explainability, but at least a level of control. And this is extremely important when, for example, it comes to the tool used for the voice and dialect recognition. How is it possible that a machine is able to associate the language I'm speaking to the Italian I'm speaking to an accent coming from more than north to the north of Italy rather than the south of Italy? So it is important for the concern of transparency that we as final users or people who are subjected to this kind of decision, we can check the fairness and the correctness of the data. And when it comes to actually exactly the point of language, I chose this specific tool to present because from a methodological point of view, it is not, I didn't find many things written on this specific tool, and I think it raised many concerns. Because from my point of view, it really raised the normative power of AI in altering what the asylum law already provides. So this kind of balance between the authority and the applicant, and also when it comes to a specific principle, like the principle of individual examination or the principle of the share the burden of proof. In this context, we see that the authority has many more weight in order to issue a decision without a real possibility for the applicant on the other side to reverse the issue. And when it comes to discrimination concerning the language, one of the main criticism was coming by the doctrine about this specific tool comes from the linguistic experts. Scholars in language studies say it is impossible to really assess the language spoken by a person because the language changes so much coming from, it depends on many factors, psychological factors, geographical factors, also environments on which we are living, and it raises many questions. I think that it reinforces the risk of discrimination because, of course, a person, in this case, Arabic speaking, coming from Syria, if in for example, a center, if he stays or she stays in a center where there are other people speaking Arabic coming from other countries, of course the accent may change. But this won't mean that she or he is not from Syria. So this is a point. So it's another question, but thank you.
Thank you so much. If you can keep your response to 1 minute, because we need to leave the room.
Actually, the answer on transparency for me also relates more to explainability for these models also, rather than transparency with respect to collecting consent. When I think it answers the question very nicely, but in my context, for example, when we consider explainability, it's also important to consider, for example, if we look at social media data and how the social media data is collected, what language models are used to scrape data from social media. And it's also interesting to explain the way that the model is built also for internal and external review. This goes to corroborating sort of the findings of the model itself. Of course, but I think transparency in the consent terms, like you mentioned, click wrap agreements that we see where we just press agrees is all that we have for now. I mean, I don't anticipate any improvement with that. Again, I'm not a data scientist, so. Yeah.
Thank you so much.
Many thanks. Was really great, and we'll stick to the time. So thank you very much. I also want to thank those who join us from remote, and I wish you a fruitful afternoon, and also to all of us here at the ESIL conference. Thanks. Bye.